You hear a lot these days about Ohio's Dormant Minerals Act, but really there are two Dormant Minerals Acts in Ohio. There was one passed in 1989, which had certain requirements, and there was one passed in 2006, which had additional procedural requirements, requiring, for example, notice to the purported mineral rights holder. So what these Dormant Mineral Acts do is they say that if certain events did not take place within a certain period of time prior to adjudication of the action or prior to a certain period during which you're looking back, then the mineral rights that were unused automatically vested, some say, or would have vested by other means in the surface owner. So that's generally what the Dormant Minerals Act does. The problem comes when you're talking about the critical period of time between when the '89 version of the Act was passed and when it took effect in 1992 after a small grace period, and when the new version, the 2006 version, went into place. So you have this puzzle presented to the courts about how to apply, if at all, that old version of the Act when considering an action brought today or after 2006, how to apply that '89 version of the Act. Did it operate to, as some say, automatically vest those mineral rights in the surface owner, or should the court apply the current version of the Dormant Minerals Act, which has additional procedural notice requirements? If it's the latter one, if the court chooses to apply the 2006 version of the Dormant Minerals Act, then there are certain notice provisions that must be abided pursuant to the Act before those mineral interests can vest in the surface owner. That's the current version of the Act, and that's the version that many think should be applied in any action brought after 2006. The reason this is important is because how to apply which version of the Act can be entirely determinative of who owns the mineral interests underlying that property. Is it the people who reserved those interests some time ago, or is it the current surface owners of that interest?
Well, and the importance of that decision comes into play in the current environment where mineral rights are so valuable. And you've got a number of companies participating in the Utica Shale looking to purchase the minerals or the rights to access those minerals, and essentially waiting or making business judgments concerning the application of the '89 version or the 2006 version. Some companies, with the recent ruling in Walker v. Noon, have decided that the '89 version is going to apply between that 1992 period after the grace, 3-year grace period, and 2006, and there would be an automatic vesting to the surface owners of the minerals. Other companies have taken protection leases wherein they'll actually lease from the record mineral owner and also from the surface owner, just in case the courts decide to follow the '89 version. It's created quite a predicament for those trying to invest a lot of money, sometimes up to $10,000, $12,000 an acre, into the development of those minerals. One of the primary issues still outstanding in Ohio, even though the geology of the Utica is as development companies had hoped, is who actually owns the minerals, particularly in instances where those minerals were severed in the past and now the surface is owned by one party and the minerals may be owned by another party. Ohio has made two attempts to resolve that issue, one in 1989 and one in 2006 through the Dormant Minerals Act.
So really what we have is a predictability problem, and producers are looking for more predictability about who owns these minerals. If courts go one way, certain parties own them. If they go another way, entirely different parties may own those rights. So regardless of which way you stand on that issue, it's really a problem for development of the rights in Ohio until we have guidance from courts other than the 7th District Court of Appeals, which has weighed in and is the highest court in Ohio to have weighed in on this issue. Until we have guidance from additional courts of appeals, including the Ohio Supreme Court, producers will be somewhat reticent to full-throatedly develop those rights.
Absolutely. The one issue concerning the application of the 1989 version versus the 2006 version, it's very significant and pertinent today. But in addition to that issue, there are several things that impact ownership under the Dormant Minerals Act more generally. To qualify for abandonment under the Act, there's a notice procedure that's required under the 2006 version. But there are no specifics as to what extent the party seeking to, the surface owner seeking to abandon those minerals to themselves actually has to go through in that notice procedure. They're searching for the holders or the person who reserved those rights to themselves. They're seeking for them or their heirs, but to what extent will their search qualify?